All right, good morning. Let's go ahead and get started with Judiciary Committee meeting. Ms. Ogden, if you'll call the roll for us.
Senator Albritton, Senator Bell, Senator Cornley, Senator Coleman Madison, Senator Elliott, Senator Figures, Senator Gavan, Senator Orr, Senator Singleton, Senator Smitherman, Senator Stutz, Senator Weaver, Senator Barfoot.
Here.
7, we have a quorum.
All right, we've got a quorum. First up is my SB 210, which deals with hospital liens. You may remember here about 2 weeks ago we had some lively discussion, the pros and cons of such bill. We have worked with the Hospital Association, tried to come up with a solution, and others over the past several months, even going back to the summer, and I appreciate their engagement. My request is that we get this bill out of committee. I will have an amendment that I think is a favorable amendment, deals specifically with ensuring that if insurance plans such as the one that's being offered and debated in the House now if that passes, that this bill would add that as an amendment there. And if anybody's got any questions, I'll ask Mr. Hosp to come and talk about that amendment. Yes, ma'am.
It's not on the amendment. I just want to make sure I'm on the same page.
Sure.
This is the one that we discussed where, just as an example, and you have to forgive me if I get this wrong, person's in an accident and they are severely injured, go to the hospital, they get treated and has a huge hospital bill, but then there's a lawsuit because the person who caused the accident is being sued and they're at fault. So this would allow the hospitals to go after that third party so that they can recoup some of their expenses for the accident?
Not entirely correct. So let me do the best I can to explain. So under current law, if you'll remember, we changed several years ago that if somebody has a private health care insurance and they're injured in a wreck, by way of an example, by somebody else, that the hospitals were mandated to file that claim or that service that they had provided for that individual who was injured through no fault of their own on a Blue Cross Blue Shield policy. But the law, but under Medicare, if you're on Medicare, elderly on Medicare, if you have Medicaid now, or if you have TRICARE for service to your country, the hospitals could elect not to file that with TRICARE or with Medicare or with Medicaid and instead file that as a hospital lien. Did that answer?
Okay, so we're saying that the lawsuit now would be against, if they didn't have any other private insurance, say Blue Cross, but they only had Medicare, Medicaid, or TRICARE, then the hospital would be filing a lien against the Medicare.
They would bill Medicare or Medicaid or TRICARE rather than filing a hospital lien in the probate court against the person who was injured through no fault of their own.
Wouldn't they be the ones that would be paying the bill anyway?
Who's that?
The insurer. Let's just say it's Medicaid. That's the only policy that it has. Wouldn't they be billed anyway? No,
not necessarily, because if you're injured, if Senator Smitherman, we're going to use you as the defendant this morning, okay. Senator Smitherman. Very good. He's got good representation. If Senator Smitherman were to get into a car wreck with you, cause the injury that you received, and you go to a hospital and you have Medicare, then this would mandate that after a certain period of time, the hospital would have to file it on your Medicare rather than filing a hospital lien against you, because that hospital lien that's filed has your name on it and it's filed in the probate court of the county that the hospital provided the services. So what we're trying to do essentially is we're trying to allow or mandate in certain circumstances that the hospital actually file with Medicare that you may have, or with Medicaid that you may have, or with TRICARE if you've served your country. And so, to me, it's a very simple approach. Do we want that individual who has been injured through no fault of their own, do we want their insurance, health insurance, be it Medicare or Medicaid or TRICARE, to pay for that hospital bill? I think we do. I don't think anybody in here thinks that that individual who's been injured, again, through no fault of their own, should have a hospital lien filed against them. We're trying to force hospitals to use the health care assurance that you have. Now, let me also say this, and the Hospital Association brought this up, and they are absolutely correct because I sympathize with them, is that their margins are very slim. And so while understanding that, if we are able to get this out of committee today, I anticipate that we will continue to work to try to make that language a little bit better and more palatable to them. Senator Smitherman.
Okay. Thank you, Mr. Chairman. You took part of what I was going to say. I was going to start out by saying that I'm going to support you to get it out of committee.
Thank you.
Right off the bat, I'll tell you that I am. But there, like you said, there are some issues, and I kind of see three of them myself. And one of them is that, and I know I'm talking to him, but it's something I'm chiming in on what you were kind of your subject matter. One of the things is simply if you look at, I would use pediatricians. You know, we have delivery, that kind of stuff. We have a limited number of people who will provide the services because the reimbursement for Medicaid does not meet the actual expenditure or cost as it relates to the service. So that's one of the concerns, is that you're going to have a reduction of people who will provide the services under the limited amount of funds they could collect. The second thing is that the detrimental side to the client or the plaintiff is simply the fact that into the attorneys too, for that matter, but in the world of selling those, and I'm gonna give you a little small example, that you have many of your insurance companies that's gonna look at the specials. And they're going to, and usually the baseline starts, there you go, you already on board, what I'm saying. The baseline is going to be lower, and usually the baseline they start out with it, you have to get them until they start out, it's 3 times whatever the specials. So if they charge $150 because of the rate and not allowed, even in this bill, for that client, for that plaintiff and that attorney to assert the actual cost of it as it relates to this process, then that a person who go out there and get half killed may not be subject to get but some crumbs so that they can survive after being half killed based on that side of the ledger. So you got the hospitals that's not going to get the money, because they're less. And then you got the client that is going to limit their ability to be able to get a good settlement, to do all in trial, a good verdict for that matter. And of course, you're going to have a limitation of attorneys because in those cases, most of those cases are taken with no fee cost if they recover. And you're going to ask the attorney to put in thousands of dollars into a case that they're not going to be able to get the judgment back at the level that they even put expenses in. It's the thing in law, we said that you're going to have good money chasing bad money. And so that is the inherent overall I see as the three-pronged problem that I'm going to put back in your lap so that you can address and handle it as we move from this committee forward. So I just want to kind of put that out there as you kind of formulate some things that you want to try to touch and approach. That those are just 3 things that popped to my mind. But no, I'm going to support you on it.
Thank you.
I very much so. And if I need, you need me to, I'll be glad to work with you if we go forward.
Thank you, sir. Senator Gavan, and then we've got an amendment I'm going to ask Mr. Hosp to come up and talk about.
So I'm sure there may be some nuances to it, but to me, it just breaks down to, I have Blue Cross Blue Shield. Why should, in this setting, I understand everything's not equal across the board and in terms of payment and how things are treated, but in terms of a car wreck or injury that is going to be potentially covered by insurance, why should someone who is poor, who is old, or is serving our country be treated differently than me. It's very simple.
Thank you. You summed it up, I think, a lot better than I did or could have. Ladies and gentlemen, I'm gonna tell you, I'm probably not exactly prepared on this amendment. I'm gonna ask Mr. Hobbs to come up and give you an idea of what it is. And secondly, LSA has not got it in format that we needed in. I think their system was down this morning. Mr. Hosp, if you would come up and tell us what this potential amendment does, and let's see if we can adopt it today. If something happens and we can't, the committee doesn't because they don't have copies, then I pledge to work with you to try to help get it on the floor.
I think everybody can hear me, right? Thank you, Mr. Chairman. The amendment takes care of a couple things. One, first, it makes certain that the amendment, when it refers, or sorry, the bill, when it refers to healthcare payers, is inclusive. As you know, there is a bill being debated downstairs in the House right now that would create a new category of health plans. This bill would simply include, this amendment would rather include benefits offered by a nonprofit agricultural organization. The other piece is there's a language that was included back several years ago when this original bill was passed. It uses the term an accurate and properly coded claim. And that language is fine, but there is existing statutory language dealing with clean claims. So all this would do would be to substitute, instead of this language that doesn't really have a statutory meaning right now, accurate and properly coded claim, it would use the existing definitions of clean electronic claims and clean written claims. It really just makes that a little more specific since there is that existing standard. And then finally, there's a provision that says a lien cannot be placed on an individual, and there's no requirement right now in the law that the. I'm gonna blow everybody out. I'll stop yelling now. There's no requirement that there be some sort of reasonable inquiry as to whether that person has health coverage prior to. It simply says a lien can be placed if they do not have it, and this amendment would also require just a reasonable inquiry as to whether the person has health coverage prior to a lien being placed on them.
Thank you, Mr. Hosp. I'll say this. I want to applaud y'all several years ago for working to ensure that those individuals who are insured by Blue Cross Blue Shield throughout the state, if they're injured in one of these situations that we just talked about, that the hospital bills Blue Cross Blue Shield in those situations rather than filing it as a hospital lien in probate court. So thank you for that. Members, any questions on the amendment? And again, I apologize because LSA's system is, we don't have that amendment yet. I think it's and to sum it up, basically it's a technical amendment with the clean claims provisions to change the existing statutory language. It also includes, should the Alpha Healthcare Plan situation come into effect, it would include them being proactive. It has no effect now unless or until that plan were to come into effect. Am I correct about that?
That's correct, yes, sir.
All right. I'd move for a favorable on the amendment. Second by Senator Smitherman. Any discussion on the amendment? Hearing none, the amendment is adopted. Thank you, Mr. Hobbs. Now we're back on the, yes, ma'am. Mrs., let the record show that Senator Weaver, Becky, abstained. All right. All right, the amendment is adopted. Back on the bill as amended. Any more discussion? If not, any opposition using previous role? Sure.
There it is.
There you go.
So whenever you mandate they've got to file that, and this from an insurance standpoint, for the at-fault party, is there anybody that has primary on who can subrogate to go after their loss with the carrier that was at fault? I mean, is there a split? Like if the hospital says, well, we didn't get what we wanted, or if, the private insurer you know, whether it's Medicare, Medicaid, TRICARE, Blue Cross, nonprofit health plan. They're like, well, we didn't get what we lost in, or what we had to pay. Who, I guess, does that make sense what I'm asking? If they're both that have a loss, I mean, can they both equally go after that at-fault party?
Well, I'm not sure that I understand your question, but let me try to clear it up the best I can. So current law is, using Blue Cross Blue Shield as an example, you're injured, you go to the hospital as a result of that injury from somebody else. Again, you're not at fault. Blue Cross Blue Shield is billed that amount. If there is a settlement, or if there is a resolution of that underlying case that somebody caused that injury, Blue Cross Blue Shield has a subrogation right. Medicare has a subrogation right, a lien on there. Medicaid, TRICARE, all of those who have paid benefits to you as an injured party have the ability statutorily, by way of Medicare and Medicaid, and then contractually as it relates to Blue Cross Blue Shield, to say, hey, you recovered something and we paid something for you in the way of hospital benefits or doctor visits, follow up after that, to make sure that they recover what they have paid.
I may not be following your question correctly, but what I think you're hitting at is, okay, the hospital still got a delta there, but the hospital, though, in that situation with Blue Cross Blue Shield, contractually they've gotten paid with what they've agreed to take, so they can't go after it. It's just Blue Cross Blue Shield. Yes.
And that's no different than if you fell at your house on your own and had Medicare or Medicaid or TRICARE. They agree to accept those payments for treating you. So, all right. Any more discussion? If not, Ms. Ogden, if you'll call the roll on the bill as amended.
Senator Albritton? Aye. Senator Bell? Aye. Senator Cornley? Aye. Senator Coleman Madison? Aye. Senator Elliott? Aye. Senator Figures? Senator Gavan? Aye. Senator Orr? Senator Singleton? Aye. Senator Smitherman? Aye. Senator Stutz? Aye. Senator Weaver? Aye. Senator Barfoot?
Aye. Thank you, committee members, and to the Hospital Association and those other entities that have expressed concerns. We will continue to work the legislative process and try to discuss this thing with you to make sure that we can get an equitable resolution for all involved. So thank you for your participation. Thank you. All right, next bill on the calendar, Senator Smitherman, SB 292.
Thank you, Mr. Chairman. This bill authorizes the State Superintendent of Education to issue subpoenas and summons witnesses to testify regarding matters within the jurisdiction of the department. It authorizes the superintendent to appoint investigators and outline the authority of such investigators.
Senator Smitherman, I'd move for first. I've had an opportunity to have some discussions about this, and I think that agency needs the ability to subpoena certain records, and I'm full agreement, so I'd move for favorable.
Mr. Chair?
Senator Albritton.
If I may make a comment, what we're doing, issuing subpoenas is a court order, correct? Is using the power of judiciary in order to obtain information and other matters in a judicial hearing. So what we're, and also appointing.
State superintendent here is sort of like, you know, how they have that round hearing.
I understand that. But again, a subpoena is going to be enforced by a judiciary authority, not an executive, but through the judiciary. And then we also have in the same bill authorizing special investigators. It bothers me a little bit here on the principle that we're bequeathing, if you will, to the state superintendent, another agency, powers of judiciary and powers of investigation. And I don't know that we have any constraints or limitations on this. Right now, if the superintendent needs matters, he has power to request, but we in the legislature do not have this same power. We can't do this, even with our agencies. We can't do subpoena powers.
I'm not going to change your conversation, but let me say this. We
that's, I would agree with that. I believe specifically the Senate Judiciary does.
Chairman of Judiciary, I want you to know, remember, the hearing with Senator Phil Poole and that situation was supposed to come to me as chairman of Judiciary. They worked it out at the end.
It worked out.
Yeah, but we had it set up. I had subpoenas flying and everything. But I understand, keep talking.
Well, the only,
You were right. Your thoughts are down the right alley. It's just that, I'm sorry, go on.
no, I'm just concerned with the principled aspect here, and that we're putting too much authority in this individual that is hired by a board. And he's not an elected official. He's hired. He can be fired, and we're giving him judicial authority and investigative authority. I'm concerned with it.
Senator Smitherman, I just, one comment real
Sure,
quick. I'd say, other agencies or other entities within the state of Alabama already have that, and I appreciate the reminder to those out there that the Senate Judiciary actually has that subpoena power, because you were exactly right.
If Senator, if it's something that is deviates from the ability of these other agencies that's here, that's not contrary to what we've already have in statute, to allow that for those other agencies, I will be glad to work with you on that, because I was going to actually get a judicial interpretation about this aspect of even my own bill, and I mean I know it implies, but I just wanted to make sure that at the same time the other side can do the subpoena. You see what I'm saying?
I follow you.
It's not a one
Follow you.
side. They get everything, and you don't have anything to know what the other side. You know, you got to defend or you got to whatever. So I said that to you to say that I'm amenable to trying to get it to where our other agencies are. And this may go further than that. And I'll definitely
Only by the size of it, I think, is one of the things. But would you consider? I don't have anything prepared
I
today,
understand.
but would you consider doing something so that we could certainly make applicable the the Crandon rule?
Yeah.
Applicable here,
Okay.
which is basically a judicial decision that if an individual goes outside their jurisdiction, they become personally liable.
I'll be willing to consider.
I mean, we have that on our cops, and
yeah.
if we're going to extend this in these ways, I think we need to have some protections. And since that's a rule they've established, let's talk about that.
I will, and I'll be amenable for us to have something that won't cripple them, but take care of the things that you were just talking about. I'll be amenable, and I'm gonna get with you soon because I know time is short. I'll do that.
Senator Stutz, then Coleman Madison, and then Weaver.
Thank you, Mr. Chairman. Senator Smitherman, two questions. One, can you give me an example of where this would be used? And then number two, how do they do it now without this in place?
Well, they really, I'll just be very honest with you, they really sort of informally make these folk come. The board, if it's board people, they'll usually when the superintendent schedules, get together, that's what I'm gonna call it, then they're gonna make sure that the people you need to talk to on their side is gonna be there. The problem that they're saying is that on the other side, they're gonna need, just like if it's two people, both of us are there, and then we're having this hearing. She doesn't have to come. That's the problem. I just give y'all what this bill is all about. They want to be able to say, no, she was there as a witness. She got to come, and then we should have the right to examine her and cross-examine her in that case. That's the kind of simplicity of what they are trying to do. When he talked to me, he said that we can't get that she's holding on to I just use this word. I'm trying to give you an example. She's got the sign-in sheets, on her own. She's doing that, and she's not going to produce these sign-in sheets. Who came in? Were they really there? Not that kind of thing. That's what he's trying to have the power to get his hands on that information. And by right, he should be able to get it. It's just there's no law saying that he's got that right to reach over there and compel them to do that. So that's in the kind of giving you an overall example as to why he want to do that.
Senator Smith, I'd add too to that. I think that my understanding is that during the investigative phase, you want some resolution, whether somebody's done something wrong or not. It's good for the children. It's good for those employees of the school system who may have been accused of something. And so this helps facilitate that, number one. And then number two, I'd say my understanding is that the different agencies don't readily share information that may be needed, and they should be sharing those. So I'm supportive of your bill. Senator Coleman Madison and then Senator Weaver.
I just had a point of clarification on page 3, number 2 and
Let me get
4C. I was just wondering if it cleared up some of the questions that's being asked as far as the issuance of the subpoena. Because even in the bottom, in subsection C1, where it says that the State Superintendent of Education may appoint special investigators as necessary within the Office of General Counsel. So, I mean, you know, at first I thought, okay, so you just designate the secretary, okay, you got time, you go out there. I don't think that's what it is.
Right.
You know, it is a process of people that's in the legal arena here for that.
I would agree. Senator Weaver.
Thank you, Mr. Chairman. Some of my questions have already been answered, but one question I do have is if there is a student involved in a dispute with someone who is, if it's not just 2 employees of the school system, if a student is involved, how far would this subpoena power translate into that situation? Would they then be able to subpoena medical records and criminal justice records? Would they be able to subpoena information about the parents? How far would this extend if a student was involved in one of these disputes?
I would think that it has to be. I'm trying to use a layman's word, but it probably has to be relevant to the case itself. You know, you just can't go out there and grab records, and then whoever's on the other side, they usually file a motion of in limine, and that means limit what you can bring into this case, and then it goes to the relevance part of it.
Or to quash the subpoena entirely.
Yeah.
If so desired.
It'll squash it entirely. Or if it's something that's sensitive, then when you have the motion and limited, then the court is going to look behind the records. It's not going to even get out there or anything. They're going to send them straight to the clerk, and then it's going to be sealed, and then the clerk is going to bring it up there for the judge, or the judge's clerk, and they'll be there. Then you'll have what's called an in-camera review. In-camera review where the 2 lawyers and the judge look at these records. And then we make an argument both ways why we should or shouldn't. Then the judge is going to make the limitation. Kind of like HIPAA. You know, you being in medical. Yeah. It's the same thing with HIPAA. You know, it just, you know how they go.
I do.
It's the same process with this.
Thank you.
All right. Any further discussion? I made a motion, and Senator Coleman Madison made a second. Any opposition using previous rule? You'd like to be a no, Senator Albritton. Any other opposition? No. Let's call a long roll then.
Senator Albritton, Senator Bell, Senator Carnley, Senator Coleman Madison, Senator Elliott, Senator Figures, Senator Gavan, Senator Orr, Senator Singleton, Senator Smitherman,
I am planning to remove reservations.
Senator
Yes, I
Stokes,
can.
Senator Weaver, Senator Barfoot.
Aye.
Okay, it's favorable.
All right. Bill's given favorable report. Thank you, Senator Smitherman.
Thank you, members, and we'll work together.
Next up, HB 360, Representative Robertson. Welcome to Senate Judiciary Committee. I will tell the folks, I believe this is the identical bill that.
Can I say something? Well, can
Go
I
ahead. Yes,
recognize? Before we get started on this, I just want to tell Representative Robertson that, you know, I hadn't talked to you. These gentlemen, some of them know that.
Yes, sir.
I worked for Judge P. Johnson. Judge P. Johnson established drug court.
Yes, sir.
I'm the clerk that did all the desk work for everybody using drug court.
Well, I appreciate you.
But my point is this. This needs to be named after P. Johnson.
Yes, sir.
Not this accountability thing.
Yes, sir.
I ain't concerned. I am not in a problem with the bulk of what you're trying to do. But
Yes, sir.
I cannot support if it ain't got P. Johnson's on it.
Yes, sir.
That's just that simple. If we gonna rename it, I mean, if we ain't gonna rename it, I'm not trying to force his name, but if we are gonna rename this, we owe that to this man.
Yes, sir.
He put 3 and 4 years of his life into trying to set up drug court.
Yes, sir.
And so I put 2.5 of mine in it. So he's the man.
Yes, sir.
Yeah, if without him, there's no drug court in this state. And so that's I don't mind getting an amendment straight so we can do that. And I hope you'll take that as a friendly amendment.
I would take that one as
Yeah.
I could be amenable to
Okay,
that. Yes,
okay.
Sir. Yes, sir.
And thank you, Mr. Senator Smitherman. I think that's the change that we actually made on the Senate version of that already, and so,
Yes, sir.
Senator Bell.
And can I just quickly say this, is that he did more than that for me. He had Boyd State. If you all remember, they still doing it right now. And for 7 years, he provided the knowledge that I needed to do and the opportunity. I was the guy at that, toward the, in the process before I stopped, doing it. I was the guy that he assigned, listen to this, y'all, to teach the kids how to be a senator. I was the one that took him in there. I wasn't no senator, but I took him in there and I told him about the lobbyists. So my point, I was just saying is that he helped me get a head start in this process. I mean, McDowell Lee and we got to be friends for 5 or 6 years straight. So you know what I mean? So I also have just a personal indebtedness and appreciation for him, because being here, when I hit the ground, I at least knew where the bathroom was.
I understand, and we're all thankful for those folks who have made a difference in our life. So, Representative Robertson, I think, with that, the committee, I think, understands what you're trying to do. We passed the Senate version with that amendment that I think Senator Smitherman will hopefully be offering on the floor. Is that correct, Senator Smitherman?
Yes, sir.
I have a first and I believe a second on this. Any opposition to using previous role?
You got to no. Do you want to be no again on that?
Yes, yes, yes. All right. Bill is given a favorable report.
Thank you, Chairman. Thank you, members.
Thank you. Next up, HB 233, Representative Baker.
Thank you, Mr. Chairman, members of the committee. This is a bill that involves terrorist threat, actually to try to clarify and change particularly terrorist threat as it applies then in the second degree. This bill really arose primarily as a result of some of the threats that have been made towards schools, and which there seemed to be a heightened flurry of these, particularly at the start of this school year, not just in our state, but across the country. And so with that, it's where what this bill is attempting to do on a terrorist threat in the second degree, which now is a Class A misdemeanor. It must be, for it to classify as a terrorist threat, it must be a credible and imminent then threat. And so with that, there are DAs that are reluctant to try to levy any charges against these that are levying a terrorist threat, such as towards a school or any other entity, a church or government building. So this would change so that on a terrorist threat in the second degree, this would change so that it would not have to, it removes the requirement that it be credible and imminent. But I would say this, that any threat, once it's received, it has to be treated as credible and imminent until proven otherwise. And so for schools particularly, you're talking about the schools are impacted, not just the degree that schools oftentimes are disrupted for that particular school day, but for several days thereafter, oftentimes parents, because of the panic that a threat then, as a threat then is made, parents will oftentimes keep their kids home for, could be 2, 3, 4 days after the threat until they feel comfortable that they can allow their child to return to school. You're talking about there's a cost to this as well for law enforcement, as they have to do a sweep of the building or such on the threat, and just this very disruptive. And so with this allows then for that the requirement that it be credible and imminent. It removes that for this, so it still keeps it as a Class A misdemeanor. However, on a second or subsequent then threat, it does elevate that to a Class D felony.
Thank you, Representative Baker. Senator Smitherman?
Representative, two things on that. One is that I appreciate what you're trying to do. I really do. I'm the senator for the majority of the Jewish synagogues in Birmingham. You know, out Eastwood, out in that area. I'm their senator, and I filed, and you all helped me pass the initial terrorist threat bill. Representative Faulkner did it in the House, and I was the Senate sponsor of it. So I appreciate what you're doing here. However, there was, and Mr. Chairman, if you don't mind me asking to see if somebody's there, someone came to my office about this bill. You in this audience? Raise your hand. You came to see me about the bill. That was you, yeah, you. That was you though. You just can't talk right now. See, she know what I'm saying. Yeah, it was. Can she come up?
If she can, but I'll tell you this, I think her voice is so hoarse that it hurt her to talk.
Can you want to send somebody else up? She came by my office, poor thing. She couldn't even talk. I said one word.
Katie, will you tell everybody who you are and who you with?
Good morning. Thank you, Mr. Chairman. My name's Katie Langer. I'm with the Office of Prosecution Services, and I'm Tricia's spokesperson today since she does not have a voice.
It was three things that, because I had the paper, I was looking for it. You gave it to me, and it was three things about it that we talked about and addressed. And I said, and that was made me feel good about the bill. And I don't know if it's something that we need to put an amendment on to address those three things, to alter. Do you remember when we was talking?
Yes, Mr. Smitherman. We have done a substitute, and that's to Representative Woods's bill. And so there's two bills before this committee that are kind of doing the same thing. And the sub that we gave you a copy of is to Bill HB 356, and I think it encompasses a lot of the changes on both of the bills and would make it much easier to prosecute going forward.
Will this bill, though, or that bill, trump the other bill? Because if they're not in uniformity, you understand what I'm saying, in the code, you all going to be going on that. And then if I was a defense attorney, I'm going to be going on this if this doesn't have that in it.
I think both.
And then you know what it's going to get boiled down to is the alleged intent of the legislature, and
I think both bills are amending the same statute, and so I think there would need to be a consensus in terms of what the final language would be.
Would you, Representative Baker, be willing to get with them so you can, at some, before we vote on this on the Senate floor, to whatever that is, that it needs to have the uniformity in it?
Absolutely.
Without, not doing what you want to do. I'm talking Representative Baker right there. Not what you want to do. I'm in agreement.
This is the first I've heard of this. One, I would like to hear how it's relative to this bill that I have. I know that Representative Woods does have a bill, so I'm not so sure that actually what is maybe being amended is relative to my bill. So I would love to hear exactly what would be asked to be amended within my bill, because this is the first I've heard of it.
Committee, let me say this. I think, if the committee is willing to get both of these bills out of committee and have the two representatives and Senator Smitherman and anybody else that's willing to see how we could meld them together if we could, then I think that's a pretty good way to approach that if the committee's willing to do that.
I'd be glad to do it, because what I don't want is that the standards that I know what you talked to me about, the standards of what has to be done.
Yes.
And I think it's good. I don't want those standards to, lack of a better word, lessen what's over here by saying something else. And you know how courts are. If you go get that court over there, that court may decide on this law.
Yes.
And then the other court, and they'll be right, both of them. And the other court may then the next time decide it that way. And we got two different, what's called, you're a lawyer, you know what I'm saying, what's called stare decisis, where you got the two courts two different rulings, and now it's a conflict, and most likely, the judge gonna say that the legislature needs to straighten it out. You know how they do some of the things, send it back to us.
Yes.
And so if you all can do that, and Representative Baker, I don't have any problem when what you all come to, you know what I mean? I'm gonna work with y'all, but I don't have any problems. It's just that I want it to be where it's not a loophole over here, you know, and we got that.
And I've read both bills, and I think that the sub that we have here would encompass exactly what Representative Baker and what Representative Woods are trying to accomplish and make it much easier for district attorneys to enforce across the state consistently.
Thank you.
Now, the sub go to the other bill, not his bill, doesn't it?
That's correct.
That's correct.
Okay, all right.
Thank you, Ms. Langer.
I move favorable report, though, on his bill.
Got a motion for favorable, Senator Smitherman. I'll second that. Any opposition using previous rule?
I'm going to abstain for the very conflicting. I just don't want bills to be put out there and we're not sure. I want to abstain.
Understand. Senator Singleton.
I mean, we get bomb threats at schools all the time. Someone call in, some of them are pranks, and I think pranksters need to be punished or made to stop doing this, because I take this very serious. Because when I notice whenever there are school shootings in this state or somewhere else around, nobody ever comes to the mic and talk about them. It's like we're sanitized to it. Like, it's okay to shoot up my babies. And we never try to act upon it. So I appreciate you at least putting something in place here. But if we get those all the time, are we talking about now calling that a threat of imminent danger and putting, if somebody just say there's a bomb in Center Street School? It would be something that simple?
No, I'm not sure. Can you
I'm asking a
restate that?
question. If somebody called in and said there's a bomb in Center Street School, it's then take it from there.
Okay, it's where, so under current law, let me give what's current law and then what I would like to propose with this. So under current law, when that threat is made to the school, once it's transmitted, communicated, it's where the officials have to go ahead and treat that as a credible and imminent threat. And so it may be that day, it could be then a few days before they find out, no, it was just a hoax. It was actually someone just being mischievous and such, but it created huge disruption to the school as well as law enforcement, all of that. So it's where, as it is now, district attorneys are reluctant to try to levy any charges because it must be proven that it was credible and imminent that they could carry it out. And so once it's where it's not actually credible that they could have actually carried out the threat. I'm just saying it was a hoax and such. It's where now there's not any ways for them to prosecute. And so this would remove that there has to be, that is just for the second offense, the second degree. It does not change anything with the terrorist threat in the first degree. So for a terrorist threat in the second degree, it would remove the requirement that it must be credible and imminent. So if it's just simply done as a prank or hoax, it allows then DAs to be able to at least to prosecute. Doesn't mean they have to prosecute, but allows them that discretion to be able to prosecute based on the situation.
And if if that individual has another prior hoax and the second one.
Correct.
Now you've got 2 times that this individual has done that, then we bump that up to.
It elevates it,
more
right, only
serious
after,
offense.
right, a second or subsequent, that's correct.
And the second will make it a D felony.
Correct. So it still stays a Class A misdemeanor for just the first time, but if it happens the second or third time, then yes, it elevates to Class D felony.
Okay, I believe I've got a motion and a second. Does any opposition using previous roles? Senator Coleman Madison, I think you said you wanted to abstain. Senator Singleton?
I'll keep my
Okay.
vote.
All right, Bill is given favorable report. Thank you.
Thank you, Mr. Chairman, members of the committee.
All right, next up, Representative Gidley, HB 66.
Good morning, Mr. Chair, members of the community, of the committee. Hope y'all are part of the community. of
That's
course.
it.
But good to see y'all this morning. Thank you for giving me an opportunity to speak and share this bill. This is a very simple bill. This bill simply extends the penalty that currently is on the books. We currently have a bill that prohibits an individual from receiving any kind of anything from a will or anything property if they commit murder from an elderly person. This extends this to if someone is convicted of abusing an elder and they're convicted of that, then they also would forfeit any rights to receive any kind of inheritance or windfall. And that's simply what the bill does.
That's it. Mr. Chairman,
Senator Smitherman.
I quickly move for favorable report.
And I'll second.
I've seen with my own eyes what you saying. I move favorable report.
And I'll second that. Any discussion on the bill? All right, any opposition using previous rules? Senator Coleman Madison, would you like to be added as a yes on that? Good. Yes. Thank you. Bill's given a favorable report. Quick
Thank you,
work.
committee. Have a great day.
Must be a good bill. Quick
Thank
work. All right, next up, Representative Woods, HB 356. I don't know if he's carrying that or Senator Smitherman or you. Oh, okay, you are still here. Okay. Matt, if you want to come up, or Senator Smitherman.
He can come on up. Come on. Come on. I was supposed to do it just for the record. That's why he's doing it, but you come on up. Yeah, I'm glad you're here.
Thank you very much for the opportunity to present this morning. I'll defer to Senator Smitherman's appropriate time. I just wanted to let you know why I brought this bill, and it does continue down the vein of school threats, similar to what we just heard from Representative Baker. But like many of you, I'm a parent of a student here in the state of Alabama, and when I take my daughter to school, I expect she's going to be safe. I expect our teachers are going to be safe. And unfortunately, earlier this year, there was a rash of bomb and school shooting threats that took place. In my home county of Walker County, there were some schools that went on lockdown as many as 6 times in a matter of 3 weeks, which led to a lot of issues. As you can imagine, loss of learning, a lot of law enforcement, first responders pulled away from critical needs to come respond to what amounted to hoaxes. I have reports of young students going to their pediatrician's office who had such heightened anxiety and fear of going to school that they had to be medicated. These are things that I just cannot abide by. And so yesterday I got a call from my wife. My daughter is under her desk in a lockdown. Another shooting threat took place yesterday in Walker County. So these are things that are happening regularly, and I hope that this bill will help address that to act as a deterrent. It does some similar things to what Representative Baker's bill does, and our sub will really closely align those two bills. But it does a few other things, and I'll be happy to defer, Senator Smitherman. If you want me to continue, I'd be glad to do
continue.
that. Sure. So in addition to the threats that are addressed in the second degree, the sub, well, we'll get to sub in a minute. I won't talk about that. It elevates those charges to act as a deterrent, but also has some safeguards in place. So when a student commits this crime, what happens? Well, I want to make sure before that student comes back to school and attends class with all of our children that they have an opportunity to have a psychological evaluation and proper counseling if need be. Because why does a student commit this act? They're crying out for help or they have an issue. We want to make sure we address that issue before we bring them back into the physical school setting. Also, there's a cost associated with this crime, right? So when a law enforcement response or a school board has to bring in additional people because there's a threat that day, there's a cost to taxpayers. This bill will shift that burden to the guilty party in the form of restitution ordered by the court. So that's the gist of what this bill does. Happy to answer any questions.
Thank you, Representative Woods. Do you, I think there's a sub, are you off, are you offering that sub, Senator Smitherman?
Is it here, the copy of the sub?
There is a copy in your binder. I have another right here
Okay.
if you'd like me to bring it to you.
You need it? If you need it, then. Let me see.
Yeah, it's in there.
If you could, Matt, tell us
Sure.
what the sub does and why there's a sub and what it does different than what the bill that.
Well, we knew Representative Baker's bill was coming up as well, and so working with the DA Association, felt like some of his definitions of credible threat were a little bit better to allow them to prosecute more effectively. We are putting the term credible threat in the code for the first time, the definition of it, which will allow all the jurisdictions to be able to prosecute uniformly across the state. And this sub clarifies that definition a little bit. It also changes the term threaten to threat, makes it a little bit more of a broader ability to bring a charge. So if you have someone who commits this or act the night before, a lot of times these threats happen the day before. And so what happens is first responders get to them, make an arrest, and they can bring charges without having to actually go through with the actual threat, ahead of time.
I've got and Senator Bell had a motion for favorable or to adopt the substitute.
I second.
It's second by Senator Smitherman. Any opposition using previous rule on this, adopting the sub? Senator Singleton would like to be a no. And Senator Coleman Madison, you'd like to be a yes. Is that correct? All right. Now we're on the sub. Thank you. Got a motion for favorable by Senator Bell. I'll second, and Senator Weaver has a question.
So the sub, is it kind of the negotiation between the Baker bill and your bill? And Is this the one?
It mirrors, and I would ask if that's okay, we bring Katie back up with the DAs because they just worked this sub out and the intent was to try to get it as close to Representative Baker's definitions as we had. It does exactly the same on the second degree offense, and making a second act to elevate that charge to a Class D. But what it does is changes the definition a little bit more, making it a little bit broader with the term credible threat is all it really does. But I think we'll have a little bit of work to do to get them identical. But I've talked to Representative Baker, and I'm happy to work with Senator Smitherman and others to make sure we get that married up, because I want it to be congruent as well.
Okay, thank you. Any other discussions on the sub? All right, any opposition using previous rule? I think Senator Singleton, you would like to remain a no, is that correct? Any other opposition to keeping the rule as it is? Hearing none, subs given favorable report. Thank you, Representative Woods.
Thank you, members.
Next up, HB 356. Nope, wrong place. 164.
Second.
Whoa, easy.
Senator Van.
Mr. Chairman, we have an amendment, or I have an amendment that we put on Senator Smitherman's version of this that we already passed, and what we had talked about was the issue of a person who had minor children, and because this would throw all the money in with the surviving spouse who might not be the mother or not necessarily mother, the parent of all the minor children.
I move adoption amendment.
Got a motion for an adoption of the amendment, a second by Senator Bell. Senator Singleton, would you like to be added as a yes on the adoption of the amendment? All right, any opposition using previous rule then? Hearing none, the amendment's adopted. Back on the bill as amended.
As amended.
We got a first and a second. Holly, you take your pick on who the second was. Bell beat him. Any opposition using previous rule as amended, as the bill is amended? Hearing none, bill's given favorable report. Thank you. Next up, we've got HB 238, Representative Moore.
Mr. Chairman.
Yes, sir, Senator
I
Smith.
move for favorable report. It's the same identical bill that I had in the Senate, same bill that we passed in the Senate.
I thought so. We've got a motion for favor by Senator Smitherman and a second by Senator Bell. Any opposition using previous rule on that? Hearing none, bill's given a favorable report. Thank you. Next up, Representative DuBose, HB 209. I believe we've seen this bill and passed this out of committee already.
I move favorable report. We passed it. I move favorable report.
Got a motion for favor by Senator Weaver, second, Senator Smitherman.
Can I ask a question?
Yes, sir.
So we sent this one down there a while ago. Why don't y'all just take that one and go with it?
This one just moved faster. April and I were looking at that last night, trying to figure out where hers was.
Moves faster.
Mr. Chairman.
I don't know how that happened either.
I'm
It just,
curious.
yeah, I don't know, because we did see that hers passed out of judicial, right? Yeah.
Senator Smitherman.
Y'all need to do some of our bills down there. I know you ain't the only person. It's 105 down there. But this here, we rolled in like I don't know what with all these house bills. And I ain't seeing nothing pop up on the main thing about Senate bills. And ain't but 35 of us, so we ain't gonna send but a few bills down there as it is.
I don't think we were intentionally holding this one back. I'm not sure what happened.
You didn't hear me say intent. Why'd y'all intentionally do that? No, but you're doing it. Intentionally or not. That's
Yes,
what
sir.
I'm saying. That's all I'm saying.
Yes, sir. I understand.
Yeah, and so I would like to see some action on Senate bills mixed in, like if you saw our calendar yesterday, half of them were House bills. And some of our senators hadn't even been able to put their bills out the Senate on it, and the body deferred to get y'all bills, even we ain't got now. So what I'm trying to say is that I understand that you all may be saying, well, right now we're gonna do House bill and we get the Senate. Well, if that's the posture, I respect it. But we need to take that posture. Well, let's don't do any House until we get through with everything that's Senate, and then we'll start doing that. So you see what I'm saying?
Yes, sir.
Yeah, it's got to go both ways. So you're just the messenger who's receiving the message. It ain't you, but you're just receiving. I would like for just to kind of be communicated in a soft, nice way that you can do it to them. I appreciate it.
So noted.
you.
Thank you.
All right, got a motion
I
for
second.
favorable and a second. Any opposition using previous roll? Hearing none, the bill's given favorable report.
Thank you, sir.
you, Representative DuBose.
Thank
Next up, SB 223, Senator Coleman Madison.
Okay, this bill is an amendment to the current law. Basically, it adds, to amend the law pertaining to expungement of criminal convictions, to add to the offense of child sexual abuse material. Any person that's committed a felony offense, a trafficking person that would not have committed a crime that, or offense for being trafficked, that they would be excluded from this. It also adds to allow a person that has been convicted of a nonviolent offense, as defined in section 12-25-32, a Class C or Class D felony, to file a petition in the criminal division of Circuit Court of the county that they were charged in to have those records expunged, as long as it does not include a sexual offense, a crime of moral turpitude, or a person that's been arrested for any of the felony offense of a minor traffic in prior years, and it has to be 5 years. And so, or disqualifying a person, if you have an offense that disqualifies a person for processing what they have a CDL, that would involve a crime for them, that was a criminal case. In that situation, they would not be able to apply.
Senator Van.
So, thank you, Mr. Chairman. Yeah, I think the first, I'm looking at an analyst report here, and the first section of someone who's being trafficked. I get that that was not something they were really trying to do. Just part of the victimization of what they were going through.
Exactly. If you're trafficking and you are forced into it, domestic abuse where you don't have any control of somebody's, in control of you, and you're being forced to do something that you would not have done had it not been for that.
And as far as the rest of it, my concern, I think I'm comfortable with that, because Class D felonies are almost a unicorn, and I'm okay with that. But the Class C, to me, is just kind of a bridge too far as expunging. So that's my problem with the rest of it. I think I'm okay with. It's just the Class C felonies.
Do you want to bring an amendment?
That's what I was thinking about doing.
But this is if it's nonviolent.
Yeah, but it's still Class C felonies is a big deal. Class D felony these days is not that big of a deal. But
okay, if you want to bring an amendment, I'll be willing to accept it. Basically, what we are trying to do is to allow those persons that have committed those minor offenses to be able to have their record expunged, so that they can go back into the workforce. A lot of this, when they check people's records, is preventing them from getting a job, or even applying for certain jobs because of this.
Senator Coleman Madison, I'd add something that I'd like to discuss with you, and I think you'll find this is a friendly amendment. If someone is adjudicated a youthful offender,
Yeah.
It's not a conviction. So I'm not sure the language in here under current law covers youthful offender. So if somebody had been adjudicated as a youthful offender and it's not even found guilty, but charged with that,
hanging out there over their heads.
that's right. I think we could probably put some language in there. I'd like to talk to you about possibly putting some language in there about that.
I'd like to get it out of the committee if possible, but I would definitely not push this until you all are the people who deal with this every day. I would like to get your help and suggestions as far as making it a better bill to cover those kinds of things, like that situation that is really prevalent.
Thank you. All right, any other discussion on the bill?
I move favorable.
Got a motion for favorable by Senator Smitherman and second by Senator Singleton. Any opposition using previous roll? Hearing none, bill's given favorable report. Thank you, Senator Coleman Madison.
Could I be just recognize us?
Yes, sir. Go right ahead.
I appreciate what the committee is doing in relationship, that if there's a concern that we can work on, and I hope that, hey, this is a caucus message when y'all get in y'all caucus, and I hope that spreaded the fact that the same thing is true when we set the agenda. If it's something that we need to work on, we should not. We see it's a problem because we don't have a third of our bills on that. So if there's some problem with some of them, then let's move to, you need a minute on the floor. We need to do something like that versus, taking a different posture. The committee does a good job. This committee does. And I hope it's extended that the whole body takes this approach, so that we can at least come to a point where the bill is palatable for everybody and touches the issues, whatever it might be. That's all.
Thank you, Senator Smitherman.
Thank you.
Next bill, and I believe the last bill on the agenda today, is HB 307. This is, you might remember, the same speedy trial bill in essence that we passed out of here. The exception to that is there was an amendment put on that does give me a little concern, but be glad to try to work. I'm carrying the bill today for Chairman Jim Hill, and I want to try to continue to work with him on that if we could get this out.
I move for a report.
Got a motion for favor by Senator Bell and second by Senator Smitherman. Any opposition using previous roll? Hearing none, bill's given favor report. And I believe that does it. Thank you all for your attendance and for sticking with us. And just for the record, I think we're about an hour, which is almost a record. Yeah. Well, you carried over y'all carried over every bill.